Okay, thank you so much. We're going to get started with our 2 o'clock panel on the cognitive limits to end user responsibility for privacy. And I am so pleased to be here with three of my friends and colleagues, Florencia Marotta-Wurgler, Ryan Calo, and Jonathan Barron. We are going to start with Florencia, who's going to talk about um, privacy terms.
Okay. Yes. Thank you. Okay. Yes. Hi. Thanks for having me. This is great. I'm learning tremendous amounts. So what I'll talk about today briefly is whether users can manage their privacy in the current regulatory regime, given what we have, and I'll present the results of some studies that I've done on the subject matter. So just as a brief overview, so the current legal regime or the current legal landscape is governed by what everybody knows as notice and choice regulation that relies on disclosure of firm information practices via privacy policies to encourage firms to compete on privacy, as well as the adoption of for information practice principles through self-regulation. But I'm going to put that in parentheses because I'll focus on the former one. So for this regime to work, two things are necessary. First, consumers must read and understand what's in these contracts. And second, they must act on what they read. And this is how the current legal landscape presents choice and an opportunity to control information to users and consumers. So what I'll discuss now is whether this current legal landscape allows consumers to control their information, which is the topic of this conference. And the evidence strongly suggests, and this is no shock, but I'll present some very specific results, that the answer is a clear no. So I'm going to summarize the findings, and then I'm going to talk about how I got through them. So, I should have clicked before. Okay, so the first finding that I'll discuss is that very few people read fine print, regardless of how prominently the fine print is disclosed. Privacy policies are also, so assuming that they wanted to read, it's also would be a very difficult task because they're, as everybody knows, they're long, incomplete, vague, and ambiguous, and I'll describe precisely how. They're also growing over time and getting more complex over time, so the trend is really not positive. And also, just to complicate things a little, and Helen talked about this earlier this morning, and I feel like I'm doing a continuation of her talk. Privacy policies change frequently, making it even harder to understand and control their information. So the first thing I'll talk about very briefly is how very few people read the fine print. And what we study from the law and economics field is we know that most people don't read, but what we ask is whether other users or other consumers can be agents of those of the large uninformed group, meaning that if consumers have similar privacy preferences, maybe a few tech savvy will be enough to discipline those who might not be. And this is called an informed minority, just as this critical mass that's big enough to discipline sellers into offering, or firms into offering, terms that are desirable for all. And this is a competitive outcome because if consumers that are savvy are uncomfortable or unhappy with the terms, they'll just go somewhere else, assuming that they can go somewhere else, which is a big if in the markets that where privacy is concerned. And we study in a different market with two other co-authors, Yanis Bakos and David Trossen, in the market for shopping for software online. There's a long contract. It's relevant for the product. And what we find is we study the visits by 40,091 households to 66 software companies for 1 month. And we use the clickstream of URLs to see very precisely how they visit each firm, how they shop, and what type of pages they click on, including the pages that correspond to EULAs. And we have all sorts of other information to see whether that affects purchase. And we say that a reader is a person who clicks on a contract page and stays on that page for just 1 second. If you're a reader, you're informed, you count on this powerful informed minority. And so after doing this, we find that only 0.1% spend at least 1 second in these pages. That is 1 in 1,000. I mean, people had an idea that maybe 15, 20% belong to this informed minority, but nobody thought it would be so low, 1 in 1,000. And this is not privacy policies, which are even harder to find. We asked whether this is enough. Maybe 1 in 1,000 is enough in a model, in a very aggressive model where it's extremely cheap for sellers to make consumers happy. And what we finding the cost of providing one term, is that no, the number is orders of magnitude smaller than what's required for sellers to be disciplined. Now this is a different market, but it might share some elements of the privacy market. I also found in other work that increasing disclosure does not result in any significant increase in readership. And these were browser app contracts. These are contracts that you have to actually have to look for, very much the way privacy contracts are browser app contracts. However, even requiring assent, even making consumers clicking I agree, did not result in increased readership. Only about 3 in 1,000 consumers that were required to click on I agree to terms actually bothered to figure out what it was that they were agreeing to. Nobody seems to care, and we can't really get assent to work. But what if users read? What would they learn from the contracts? I mean, and more realistically, can we trust some savvy intermediaries to read and digest these contracts and display them to consumers in a way that would improve their understanding? So what I did in a recent article is I examined the effectiveness of notice and choice by looking at the terms of the contracts, whether the practices are explained in privacy policies, and evaluate whether users could be able to become informed about information practices and their privacy choices. So what kind of choice menu and term menu has the current regulation resulted or produced? And so I looked at the privacy policies from 248, mostly US firms, and these contracts are tracked in 69 dimensions that deal with notice, choice, sharing, and all sorts of other legal aspects, change of terms clauses, dispute resolution, and all the types of terms that have been litigated and that have been subject of FTC enforcement actions, and also terms that involve sharing data with government. There's a large range from very large ones like Facebook and Google, but also very small ones, niche ones like VeggieDate.com. They're very niche dating sites. And there's 6 markets where information sharing is quite salient, and we wanted to make consumers aware that they were giving all this information so as to make them more likely to read the privacy policy and maybe actively look around. And these are dating, social networks, special interest boards, news and reviews, cloud computing, and games. Of course, these markets differ very much from one another, and you see differences across markets in the terms that you see, and also other types of company, product, and market characteristics. And so the first things that I look at is, how salient are these contracts, and to what extent have the companies or firms adopted these smart disclosures or layered notices whose initiatives have been roaming around for the past several years, particularly in the latest FTC privacy report. And what I found is that 90% of these policies are available on a link of the main page, but only 18% use click wraps. And these are mostly subscription services where you actually have to agree to something, and there's more relevant what's in the privacy policy than in the terms of use. Yet the privacy policy is not the salient document, it's just incorporated by reference in the terms of use, thus making it legally binding even though you're not specifically agreeing to it. Only 22% have adopted the layered notice approach as required by or at least suggested by the FTC 2012 report. So if you really want to become informed, you need to read the entire contract, and Helen talked about the limitations of that. So it looks like these recent calls to increase contract salience in the terms of making them more visible and simple language seem to have been ignored. Probably wouldn't have made much of a difference anyway, but it just shows a bit about the state of the industry. But then we focus on what's there, and what's there is highly unsatisfying, because these policies are painfully, as much as they're extremely long, they're painfully incomplete. So it's hard to get a sense of the privacy practices. 30% don't disclose what type of information they collect or whether they collect it. 35% don't disclose any type of data sharing practices, and 76% do not explain choices for information sharing. Now, this was particularly difficult for me to code and analyze, because coming from a contracts or a point of view, there's usually default rules that fill in gaps in silence. When a contract says nothing, there's usually a set of rules that fill in those gaps. These rules barely exist in the privacy context. So when a contract is silent as to something, it's very hard for a user to understand whether the company is allowed or is not allowed to do things. Now, there's some very small and modest FTC jurisprudence as to some types of silences, but that's clearly not enough for informing consumers. So there are no default rules, and silences are problematic. And what's there is unclear and vague. So words as affiliate and third parties are defined very little. So 7% of the times, even though they're used in almost every single contract, and only 10% identifies the recipients of shared data. They have all sorts of mitigation phrases, such as occasionally, or what they may do something, or they might do something. 97% of them do, and these words appear about an average 20 times per contract. So whereas it makes sense in a way to give firms flexibility to adapt their ever-changing business models or adapt to the ever-changing technologies, it's very difficult for consumers to understand what it is that's happening with their information, or what it is that they can do with it. Also, several terms are internally contradictory. So whereas one term says that the information will not be shared with third parties, another term will say that third parties are allowed to track and collect all sorts of information there. And this happens quite often and for a variety of terms. So this graph shows that, and I have some longitudinal study that shows this in a much more direct way, but this basically shows the privacy policy by the year of the last time it's been updated. And what you can see is that contracts from 2004 have an average of about 1,200 words, and as the contracts get updated more frequently, the number of words rises. Now, these are different types of contracts, but what I have in a study that tracks the same policies over a period of 5 or 6 years, you see the exact same rise, about 30-35% increase in words over this period. So contracts are just getting longer, and they're equally hard to read. So it's not that language is getting simpler, we're just adding more and more terms and not deleting any others. So this again complicates assent. There's also very limited control about what users can do with the information. There's some control over information. These are particular sites because they're several are social networks where consumers where users can add or delete information, at least to their view, but the company still collects it. The contract says that 60% of contracts say that they allow users to delete or anonymize the information. This varies greatly by market. And 3% allow access or correction to that personal information. But once the information is shared, any type of control goes away. Only 2% give choices in case of sale or bankruptcy, and only 13%, 20% bind affiliates, 20% contractors, and 4% third parties to the same privacy policy. So you might have certain expectations, but once the information is gone, the practices could be whatever the third parties' practices are. There's also very little choice. 26% offer opt-in choice to personal or sensitive information sharing, although most of these firms don't really explain how that choice can be exercised. So there are these empty choices or just ghost choices, and 7% have opt-out. It's been very hard to make sense of these terms. And it's also hard to keep up. Most contracts have change of terms clauses that have mostly been enforced by courts. This allows firms to change terms unilaterally as long as there's some type of notice. Only 9% will email users informing of any changes, and only 10% will require any type of explicit assent to these changes. Now, the thing is, these terms change quite often. An average of 2 times a year. But that's drawn by some that don't change at all. Some change up to 10 times a year or more, some up to 20 times a year. So these contracts are fairly dynamic. So to conclude, there's not much control, and not that everybody things that people don't know about, but it's good to get a sense of what these contracts look like. There's not much exercise of control over the information with the tools that have been given by notice and choice. Hardly anybody reads the fine print. The policies are not salient, they're not explained in a short way, and they explain information practices very poorly. There's silence on important categories, terms are vague, and maybe they're users are better off with other means of protection. But I think the message of this is not so much that users will not understand it. The contracts as they're written cannot help intermediaries in any meaningful way. You know, if we're having some hope for intermediaries or some sort of automated way of digesting these contracts, the way in which they're written makes any type of legal analysis or digestion of these terms extremely difficult. Thank you.
Great, now we'll hear from Ryan Calo from the University of Washington.
Can I just change the?
Yes, of course.
I think I can do it. Right there. And then, can you make it start? Yeah.
It's under the keyboard.
Okay. Sorry.
This one, right?
Thanks.
Yeah. Awesome. Thanks a lot. Move this keyboard out of the way. All right. Okay, so I'm not going to be doing any better job than the master herself, Florencia, in dramatizing for you the limitations that consumers face in trying to digest written documents like this one. This is, though, one of my favorite examples from 2010, where a game station, if you didn't see that in the time it was up, actually asked you to surrender your immortal soul if you didn't opt out, as a way to sort of dramatize some of these pictures. You know, and to Florencia's point, I mean, she's looking at contracts, she's looking at privacy policies. There's also been some important, I think, work done in terms of trying to simplify things, recognizing that just straightforward text is not the kind of thing that people are going to be able to engage with. And so I believe this is Ashkan Soltani's work from Berkeley, right in the upper left. Isn't that your stuff? Yep. I think this is Lori Krainer's, isn't it, on the right? I think I saw Lori. There she is, exactly. And then this is what Helen alluded to before, Glamleach-Bliley. And so the idea is that you can try to simplify this stuff so you can do better comparison, and you know, it helps. It doesn't help enough. It reduces the amount of time it takes to digest this stuff, but at the end of the day, it doesn't do that much. So I want to talk about is whether there's any way to break through these cognitive limitations that individual consumers take place. And so here, I want to show you something a little bit scary. All right, so take a quick look at this thing. Just a show of hands among you. Who among you would want to go down and give a hug to that clown? Is there anybody who would want to hug the clown, right? And so it's like, well, why not? I mean, first of all, hugs are good, right? Hugs are a nice thing, you know. I mean, I love hugs, and they're free. And free is, you know, there's no cost to you. It's free, right? And this is a clown. A clown, which is the purpose of a clown is to It's to entertain and you know, they're beloved. And yet, this thing screams to us that you should not be going anywhere near this particular individual, right? This is also the reason why robots are not going to be taking over anytime soon, because the robot is no way to get the semiotic meaning behind this, right? They're going to be like, oh, hugs, and they're going to hug, right? So this is something that humans can do because of our ability for context, right? And so the point of the slide is to say that sometimes, in fact very often, the subtext is far more important than the text. So my research into this area got launched essentially by the work of Alessandro Acquisti, and this is a study that Acquisti did with two of his colleagues. I want to say it's Lowenstein and Leslie John. Is that right? Yeah, the context willingness to disclose. All of this work, of course, is on Alessandro's website, and take a look at it. It's amazing stuff. And what he showed, and his colleagues showed, was that if you were to make something more formal, that it would actually drive down your willingness to answer controversial questions like the one on this slide. So compare this slide to this condition. How bad are you, right? And this is Alessandro's the beauty of his work. It's you know, this is the sort of, you know, environment in which people will be more likely, not just statistically significantly, but, you know, actually significantly more likely to answer questions about themselves, right? And so I took this as kind of a departure point and started to ask myself, well, how can we make this work that's so wonderful a little more policy relevant? Because the conversation that was occurring at the time was about not what consumers were, say, willing to do or not do, but what they understood. And the panel that we're talking about today is about what people understand, not necessarily about what they do. And I'm going to disentangle that a little bit. So we, that is to say Victoria Groom and I, who was at the time a PhD candidate in Cliff Nass's lab at Stanford Communications Department, we did a kind of a version of this where one of the differences was that we had this thing called web search, and we tested both and so this is the two conditions. You see this one's this and this one's less formal. We tested not just whether people would be more willing to disclose things about themselves, but we also tested something I want to say is called passive disclosure, which is the idea that you're not directly giving up information about yourself, but rather there's information about yourself embedded in an answer. So for instance, name a celebrity that grew up in your hometown. Like that would obviously tell you what your hometown is, but it's more passive. And the other thing we looked at for our purposes, maybe more interesting, was what was your mental model of what was going on the back end? What did you understand about these practices? Now, you're not going to be reading the privacy policy. You're not going to be reading, and even if you did, it wouldn't make any difference because it changes and all the things Florencia said. But what we found was not only were people more willing to engage in passive and active disclosure in Alessandro's casual condition, but they actually were less likely to say that the website was keeping their information. In other words, we asked them questions about, do you think that this website retains your information after your search? And in this condition, they were more likely to say it was than in this condition. You see? The other thing we thought about was, to the point that was made earlier about robots and the illusions we were talking about this morning, we thought to ourselves, well, what about another way to sort of affect what people are willing to disclose and what they understand? And one of the candidates we thought was anthropomorphism. So this is a slide that I love so much. It's from Lee Sproul's work with her colleagues. And what it's showing you is the fact that people are more likely to pay for coffee on the honor system if you put a pair of eyes over the collection basket than flowers. Okay? And what's interesting about that effect is that it's pretty robust over time, right? So after a couple months, you're still seeing this difference between people's willingness to pay for coffee on the honor system, right, with the eyes than with the thing. So it's actually kind of robust. So we thought to ourselves, well, let's do the same kind of experiment, but instead of having casual versus formal condition, we'll have an anthropomorphic condition. Right, and so we actually had this woman from this technology has evolved, but we had a woman asking sort of what would you like to search for to my back and forth with Hal this morning, right? The idea that that perhaps if you had an anthropomorphic agent, it would make a difference. We also looked at other things like what if you displayed people's IP address or their current location, or that you knew what their browser were. In other words, revealed information about what we were doing. What effect would that have? Recently, to my delight, especially because they consulted Alessandro to make their thing more wise, the European Commission did a much larger N study looking at things like anthropomorphism and seeing what the effect might be. So they recreated this experiment that began with Alessandro, that Victoria and I did, and they started to do things where you would be searching for information with a very heavily anthropomorphic agent. This is a dynamic agent that talks to you and so forth, although they also did a static agent as well. And they tried to measure the same things, active disclosure, passive disclosure, and so forth. Interestingly, for my purposes, what they found was that you are, if anything, more likely to disclose to an anthropomorphic agent. So it actually ran counter to what my intuition was and was more in line with what Kelly was, what you were showing, which is that people would be maybe more trusting of an anthropomorphic agent. They had a lot of different kinds of results, and one of them I thought might be interesting to highlight to you, in part because it does sort of has some promise, is that in an anthropomorphic condition, and particularly dynamic anthropomorphic condition, people were more likely to notice there was a privacy policy link. And it was pretty pronounced. And people were, if there was an anthropomorphic agent there asking you the question as opposed to just being blank, people reported seeing the privacy policy link. Now, exactly why that might be, we're not totally sure. But the point is that they recreated this in another place and so forth. So why would this matter from a policy perspective, as I alluded to? Well, one is that think about the insight that you are more likely to disclose personal information in a casual setting, and you are less likely to understand that collection or processing perhaps will happen on the back end. And now think about what are the most casual websites on the internet. They're kids' websites. And now think about the fact that there are specific laws. We're particularly concerned about kids, so much so that in a place where we have sector-specific legislation only, we decided that kids was one of the places we would have rules, right? There's a disconnect here. This is very informal setting, and if we know, and what we're seeing in these limited contexts is that people are going to be over-disclosing and people are going to be not understanding what's happening on that back end. Of course, I'm overstating and generalizing, but that's a possible insight. So that's, I think, one issue is the fact that we have to look at design, and I would recommend people like Woody Hartzog who are digging in on this really deeply. But I want to highlight something else too, and I apologize, this is a little bit graphic, although I purposely selected the images that were not quite as horrible as some of the others. But I don't know if anybody remembers here the fights that were occurring when the FDA decided that it wanted to put forward graphic warnings on cigarettes in the United States. All right? And it had these really graphic warnings, and these are not even the most graphic. There's one where someone's laid out as a cadaver, and they're a post-autopsy cadaver, and it says things like this. And this was challenged, as you might imagine, by the tobacco companies. And in the Sixth Circuit, they won. In the Sixth Circuit, the FDA won, that they lost. And the idea was that actually this was just a more representative, visceral, clear way to convey the information that cigarettes are bad for you. It was thought to be mere information, which is permissible under a First Amendment challenge, right? Whereas when the DC Circuit got a hold of this, they went the other way. They actually invalidated these graphic warnings, and in fact, the FDA has ultimately given them up on the basis that it's not that the FDA wanted to tell you better that cigarettes are bad for you. It's that they wanted to make you smoke less. And for them, the smoking gun, if you will, was the fact that that FDA actually cited to European studies showing that the introduction of graphic warnings caused people to smoke less, right? And that was a major issue. So the point is that when you decide to depart from just text, the way we talk about in privacy all the time, and you enter into a world in which you want to do something more evocative, more design emphasizing, right? That's acting on some part of the brain other than sort of immediately the language center. When you want to get visceral or semiotic about it, a couple things might be going on. First of all, you might be able to overcome some of the traditional limitations of notice. And this is this concept that Helen was nice enough to allude to of mine, called visceral notice, and I assemble a lot of examples in a piece called Against Notice Skepticism in Privacy and Elsewhere. But I think another really important point is that you can also use design elements in order to drive down or change the behavior that you're interested in. And that this differs as a regulatory mode than making things unlawful. And so another way to say that is that you can nudge people away from practices you believe are harmful. And again, not to, I guess when I was in high school, we used to say sweat. I don't know if people say that anymore, but not to sweat Alessandro. But his work and Laurie Craner's work on basically privacy nudges are really instructive here. The idea is that you can use design to create an environment that allows people to protect themselves better. And in fact, companies sometimes do stuff like this. Facebook, while it has in many ways been aggressive about causing people to disclose more information, it has also in certain instances created tools that permit you to sort of understand what you're disclosing. For instance, the ability to look at your profile as though you were another person, right? So if the first takeaway is, if we think that notice is a strategy that we should be pursuing, we need to get much more aggressive and much more interesting and creative about how we're doing it. And the truth of the matter is there's lots of people designers, graphic designers, companies, and so forth, that conveying complex information in a simple way is what they do for a living. That's what Facebook does. That's all that Facebook does, right? And if it were interested in this way, it could do it. And the second one is we need to appreciate that there are a bunch of different tools in our regulatory toolkit. There's the idea of notice. There's the idea of informing consumers so they can make a better decision. There's the idea of nudging. The idea of nudging people away from certain kinds of behavior, and there are others. And so we need to avail ourselves of the full regulatory toolkit. So I had a question slide here, but we can wait until after the end we can talk about the questions. But thanks a lot for listening. Appreciate it.
Thank you. And last, we'll hear from Jonathan Barron of Penn.
I made a handout, and I think everyone here has one, but I would hope, let me fix it so that this is for the benefit of those who are not here. We're just going to show the handout as a PDF. I didn't realize there would be people watching not here. I don't even know if there are, but okay, thanks. I want to, the handout is just about a study I did, but the point of this study was to look at what people want from the law. The point of asking that is that it's possible that the demand for laws to protect privacy doesn't match the need for such laws, and that could result in inefficiencies where people should be protected but they're not, or they should not be protected but they are, leading to someone else's harm. And when I say should, I want to take a utilitarian view. I'm a card-carrying utilitarian. This is very similar to the economic view, and it's identical to some versions of economic theory. And the basic argument, I'm not sure, somebody must have stated this, but I did it myself and it might be wrong. The basic argument is this: we should be protected. I'll start with the should not. In deciding whether the law should protect people's privacy, we should consider the relative costs and benefits. Costs and benefits to everybody. Benefits very broadly construed. They include things like being emotionally upset that somebody's seeing something. Costs could involve many things also, such as the cost of enforcing the legal restriction if there is a legal restriction. And so this cost-benefit comparison has to be made with respect to particular kinds of legal restrictions, of which there are many different ones. But I guess my own bias is that there's too much demand for privacy law where it isn't needed. And I think there are probably also cases of insufficient demand where it is needed. Maybe it's just, this is what I read about in the newspaper and it's not representative. So I tried to do a sort of very preliminary study where I made up cases that went both ways on these two criteria. Oh, sorry, that's the first criterion is costs and benefits. Forgot the second one. The second criterion comes from the economic analysis of tort law, but I think it applies here, and it's the question of who is the least cost avoider. And I'll show you a really good case that I think is a really good example of that. That is, even if the costs of breach, let's say, are greater than the benefits, there still is no need for legal regulation if the target, the person who has the information, is the one who can avoid the release of that information most easily, so long as the target knows that he or she is not going to be protected. So that would be an important feature of this. So the handout shows, I did this study, it's a preliminary study in which I asked, and I just gave the whole study verbatim in this handout, including the introduction. I don't think I can work this thing. All right. This works, okay. So this, you can just see the introduction. I'm not going to say anything about that. And I gave 24 cases. They were presented in random order on the web to each subject. And there were a bunch of questions after each case. The subjects were, interestingly, they were members of my own panel who I have this panel of people I've collected for 20 years who do answer questionnaires that I make up on the internet. And they've given me a fair bit of personal information about themselves along the way, including their name, their address, which I have to have in order to pay them, their PayPal accounts, that's how I pay them. And for a while, I had to collect their social security numbers. I finally convinced the IRB and the accounting department of the University of Pennsylvania that the greatest risk to my subjects, by far, dwarfing anything else that the IRB ever thought about, is identity theft. And they never thought about this in the years when I had to collect Social Security numbers. But anyway, I don't have to do that anymore. But some people, I still have them from the old days. Actually, I think I deleted them on purpose. So I asked these people, I presented these cases in a random order and asked a bunch of questions about them. The most interesting ones, I'm not going to talk about all of them, I'll talk about a few, there just won't be time. But the first one is the most interesting one. A man in a nearby apartment building uses a telescope to watch a young woman get undressed. The woman has left the blinds to her apartment, to her bedroom open, and the lights are on. This to me is a prime example of someone being, of the target being the least cost avoider. And I can attest, as a resident of Center City with a pair of binoculars, that this never happens. People do know about this, and they do close their blinds. So that, in a way, that turns out to be the wall case, the second one. A man in his apartment building puts his ear to the wall in order to hear what his next door neighbors say to each other. He finds it amusing. This was myself when I lived in Canada. I had an apartment. They were the most amusing people I have ever heard. But I guess that was, I don't know if it was legal. I never told them. Hope they're not here now. Okay, and then these other ones are not so interesting. I mean, all the ones are interesting because they raise various issues, but I don't want to talk about them. There's a bunch having to do with medical information. This was inspired by my own visit to get blood work, and a woman came and said, would you like to donate a small vial of blood so that we can track your genetic information and correlate it with the disease you die from when you disease and do other things with it? And gave me this thing to sign, which I signed, and I proclaimed in a loud voice so that everybody else in the waiting room could hear me, you shouldn't have to ask. And that's the way I felt. But in any case, that was the case. And there are many cases like this with different kinds of information. And I think in some Scandinavian countries, they don't have to ask for stuff like this. I know they don't with educational tests. Some of the really great work on IQ testing was done with databases from Denmark, where everybody took the Ravens matrices when they were 18 years old or something. Okay. The case labeled He Law is based on a real court case, which I think was finally resolved after about 10 years in the courts. You might be familiar with it. Another one that's kind of interesting is Candid Photography, which I think we have being done, and I think what's interesting about that is that there is actually, I think, some ambiguity about what the law says, to the point where my son, who is a world traveler, actually avoids doing it in certain countries because he believes that it might be illegal there. So, although he, otherwise takes lots of pictures. Okay, the questions were: is this okay? There's the release of information acceptable? Should it be a crime? Should it be compensated? Should the target have to give permission? Should targets like this protect themselves against this kind of information release? Which is easier? That's the least cost avoider question. And then there's a bunch of other questions. The critical one is greater. If this release is allowed, which is greater? The harm to the target or the benefit to everyone, including the target, or uncertain, it could go either way. And I didn't count those answers. Okay, here's the results. Oops. Okay, the main result is here. These are all the cases. The horizontal axis are the cases where the target is the least cost avoider, but people still want the law to do something. This is the percent of cases out of the whole sample where that happened. And you can see the most extreme example of that was the telescope. That is, people, about almost 70% think that the target is the least cost avoider, but they still want legal protection against that. The medical cases cluster up at the top. Those are the ones where not everybody, but nearly half the people think that the benefits are greater than the costs of allowing this release of information, but those people still want the law to protect them from that. I also did it the other way. That's just for your information. I'm not going to talk about that. So looking at those critical cases, we can ask what kind of protection do people want the law to give them? Well, this kind of blew me away. The telescope one, the 86% of the people think that it should be a crime. That is, you should be sent to jail for looking at your neighbor with a telescope. That was, and yet those 96% think that you should defend yourself. You could easily defend yourself. And it would be easier for you to do it than for anybody else to do it. So I think that a lot of people, so the conclusion I draw in general, and you can see from the graph that it's true in general, is that people almost totally ignore the question of who is the least cost avoider in deciding whether the law should protect them or not. They do not totally ignore the question of costs and benefits. There is a correlation there. People think that if the benefits are sufficiently great overall, then this kind of transfer of information or release of information should be legal and not protected by the law in any way. And when you look at, and this is a deficiency in the study, when you look at what protection they want for the medical cases, it's not compensation, except for the He-La case where I think that was a legal issue. But mostly it's permission. And I think what I need to do if I do a follow-up study is find out what they think permission involves. In fact, when I was in that waiting room, most of the people did not give permission. So in fact, by requesting permission, you actually reduce the usefulness of the information, because that information is most useful the medical information, it's most useful if you get it from everybody. Same with educational information for research purposes. So the conclusion I come to is that here's some preliminary evidence that people are asking for legal protection in some cases when, by their own judgments, it should not be provided according to a utilitarian analysis. And the opposite occurs too, but I won't, I think I'll stop. Okay.
Great, thank you. Thank you all so much. This is so interesting, and I'm still thinking through some of the things that came up here. So my approach to some of these issues is in some ways probably similar to Florencia's, in the sense that I also come at this from a contracts perspective, and in fact otherwise don't know tons about the privacy space. So my questions will perhaps be tinged with this flavor. The first question that I thought I would raise for all three of you, which perhaps brings the three papers together, is the question about salience, which in this case I want to also bring in John's paper, which isn't otherwise obviously about a salience question, but I think that the items, the scenarios, raise the possibility that some of the consequences of a policy are more salient than others. So in other work of yours, John, for example, you have suggested that people are unlikely to look for sort of reasons something wouldn't be true, right, or counterfactuals in this kind of way. And I'm wondering if in many of these scenarios, the potential harms of a policy are not obvious, if they are not salient, and if perhaps the raising the potential harms is also what privacy notices do when they're working, right? So making harms salient is what's going on when we perceive a distinction between functional and non-functional privacy notices, something like that.
So assuming that's how I also understand the contract perspective. So assuming that people even read and digest the contract, there's the issue of whether they can understand the cost of this, or what the implications of these particular privacy notices, and that's so as a fundamental matter for them to understand it, they need to understand harms. And I think Alessandro has done some great work on this, about how difficult it is to ascertain the harms of these types of for violations of these types of contracts. That's an additional wrinkle. So not only are they not read, not only are they complicated, not only are they impossible to understand and they're vague, but also the consequences of these types of breaches of these types of contracts, or the existence of these types of terms might also be difficult for consumers to understand. And perhaps an interesting taxonomy, or an interesting way of thinking about it, is to perhaps divide the terms among those that where the harm or the cost could be readily understood versus those that cannot. And maybe those that cannot could be taken out of the realm of notice, just because it's impossible for consumers to understand it, because it's just not a failure of language, it's a failure of comprehension. Relatedly, there's also a problem in the enforcement of these contracts, because courts are having a hard time articulating the harm as well. We were talking about this over lunch, about how difficult it is to understand these probabilistic harms, and what a problem courts are having in trying to expand the notion of harms, to the point that I think David Vladeck for a long time was talking about expanding the notion of harm in order to make these contracts or these terms legally actionable. And that goes even beyond what consumers can understand. So yes, that's true. That's an additional roadblock to this notice and choice, or notice and consent model, is how difficult it is to understand the consequences of agreeing to some terms, and the consequences of the breaches. Perhaps security breaches are more understood. And then it's a different category.
It strikes me that if you give your social security number, the possibility of harm becomes quickly salient, right? You exactly know what you're afraid of. You're afraid of identity theft. Whereas this is not the case here.
So I just want to take the opportunity of your excellent question to sort of clarify a little bit my thinking here. So for me, there's kind of a hierarchy of intervention, right? So I would, for a variety of reasons that I outline in a essay called Code, Nudge, or Notice, I believe we should have a preference for facilitating people to make the decisions that they believe are in their own interests, versus putting up roadblocks and trying to push them into something, right? So whether making something illegal, or it's nudging them away from it, and so forth. And so I think one of our tasks is to identify what are the kinds of things that you can actually get across to consumers, right? And this is a version, I think, of what you're saying, which is there's a set of things that people care about, and those are the things that you're going to want to try to aim at, and there's a set of things that you can convey. And so we're reasonably good at conveying certain things, like the existence of danger, or, there's a number of things that we can convey. And in doing so, we can then in turn rely upon the consumer to make a decision in her best interest. And this goes to Helen's point this morning, which is that, yeah, she could exercise choice, but there was an infrastructure or structure in place that permitted her to be able to do that, right? So it was a facilitation of her to be able to take her own. Other things we're never going to be able to adequately convey to people, right? There are certain things that for a variety of reasons, having to do with their cognitive biases, having to do with other limitations, we're never going to be able to do it. So for those set of things, perhaps we draw from elsewhere in our regulatory toolkit, right? And maybe we don't start with making the practice unlawful or forcing a particular business model, but rather we're more in the realm of graphic warnings, where we're somewhere in this area, this twilight between nudging people's trying to change behavior and trying to change people's mental models. The point is that, in my opinion, for all that's at stake, and for how much we talk about this, we have not systematically gone through and tried to determine what is it that we want consumers to understand, what is it possible to convey to them, what are the avenues to do that, right? And if we did, then maybe and this goes to something that Dick Craswell had written a couple of years ago at a symposium for Washington Law Review, where he talks about usually in any given regulatory context, the level of disclosure that would be best, would be optimal, is almost never zero, right? In other words, notice and disclosure is always going to be helpful in some way. The question is how do you maximize it to get the and I'm sort of increasingly of the view that that's wise, but I would expand it to say that you have this broad regulatory toolkit with different features.
So the question was,
So in part, my question was, so as I look at the items here, I think that in some ways these items present much the way that the internet presents itself, which is to say, sort of benign. Right.
Oh, okay.
And they don't automatically trigger for me the question, the possibility of something nefarious happening. Right. That's
indeed, and nor do they automatically trigger the benefits. And a lot of the benefits are for other people. They're social benefits. And for Google, for example, they get all this information about you so they can target ads. Or someone can, and the ability to target ads is what enables them to get the advertising business, which what enables them to give you all this stuff free. And so that if you opt out of that, you're failing, you're defecting in a social dilemma. And I think a lot of people don't know that. They don't think about that. But they don't think about that. And then there are also, I think, risks that they don't know about, and some people respond to that in different ways. Namely, if I don't know, it can't hurt me, or if I don't know, I better be careful and stay away from this whole thing. But and that's just a matter of individual style. But I think to follow, it would be nice to inform people about what the risk is that they ought to worry about, which is often not what they think they ought to worry about.
This leads to my second question. Then I'll open it up, which has to do with what people ought to worry about. So one of the things that I find very compelling and very confusing about this privacy conversation is that it's very hard to sort of see to understand the sort of normative stance, which is to say, what are consumers supposed to do? And especially with privacy policies, I'll maybe start with the sort of notice question. I think one of the tricky things about notice in this area is that notice may bring with it a sort of a normative position, which is to say you should be reading it. If we're showing it to you, then you should be reading it. But of course you can't possibly read it, which means that later on if something bad happens to you and you haven't read it, then you are to blame, even though you couldn't possibly have read it in the first place, which strikes me as being a somewhat vicious circle. And so I guess my question is what are the effects of the facts of notice, and are there conceivably sort of perverse effects of the fact of privacy policies?
Well, under the current legal system and the duty to read, there are clear perverse effects. So assuming that notice is sufficient as deemed by a court, then a consumer will have been deemed to have agreed to everything. And so what companies focus on mostly is the effectiveness of disclosure. Now, in other work, I found that the contracts that are the most disclosed and that require more more actions and ambiguous actions of assent by consumers of agreement, basically the ones that most resemble a signed contract and that have all the signature of formalities are the ones that are the most one-sided. And it makes sense, right? If nobody reads anything at all, I'm going to increase the chances of enforcing a term or a contract that's mostly one-sided or relatively more one-sided if I comply with all these other things. So the perverse effect is that a notice and choice model that relies on this myth of the informed consumer and puts too much emphasis on the effectiveness or how appropriately disclosed a contract is without really questioning whether a contract is read or understood, or even if understanding is ever possible given the problems with harms, creates all sorts of perverse incentives. And we see some of that. I mean, I didn't put the slides on that shows like all the incredible collection that goes on regardless of the business model. So firms that have firms that give you information, that basically give you free products, collect the same amount of information of firms that get an income stream from you because you have to pay a subscription. There's no real difference in any of that, and that's because it's free to grab all this stuff, and nobody cares, and courts generally enforce them.
I have a question for Francesca. Is it okay to ask?
Florencia.
And anyone else. Part of the problem with these standard form contracts and EULAs and stuff is that they're like warning labels. They include every possible thing. So in part, you don't know which of those things is really worth worrying about. But the other thing is I don't read those. I'm one of the 99.9%, except the ones I do read are the copyrights from publishers, because those actually have terms in them that are sometimes interesting. Like you can put it in your own webpage or something like that. Yeah. And because it makes me feel less guilty when I do it anyway, to know that it's okay. But am I being irrational to think, I'm going to sign this thing without reading it, because if I think about it a few minutes, and I have, there's nothing that could possibly happen to me that would make me refuse this agreement. You want to read my email? Go ahead. It's a cure for insomnia. That's I just can't imagine. So am I missing something?
No, it might be perfectly rational not to read. I mean, after all, these are low probability events. It doesn't mean that in the aggregate it can account to very big costs. In fact, Lori has a great study where she estimates how long it would take us to read these policies, and the billions of dollars lost in revenue from the lost time and productivity. So it might be perfectly rational not to read them, which doesn't mean to say that they should say whatever they want and the company should do whatever they want. Well, so that's somewhat but it could be perfectly rational. That doesn't mean to say that at the end of the day that at the margin there might be things that you might rather not be agreeing to than agreeing to.
I just want to jump in. So I feel like maybe my role should be to do a more full-throated defense of notice as a paradigm, right? Because so first of all, as Peter Swire has argued, there are multiple reasons you do notice, and some of them have little to do with what the consumer actually reads. Peter has written about how having to take a catalog of information you have within your organization and write it down was actually a pretty effective way to get better data hygiene, because companies were forced into the exercise of saying what they did, even if no one ever read it, right? There's also this catch-22 where you have a situation where supposedly the audience for notice is a bunch of consumers who are never going to read it, right? In theory, the audience for notice could be Ashcan, could be regulators, could be very sophisticated activists, could be a lot of other kinds of people. Now, when they read those, is it useful? Not usually. Why? Well, because it's not written at a level of technical detail that lets anybody understand what's really going on. So do we abandon it then? Well, no, because there's another way, right? You could have, in theory, abandoned notice for the most part for consumers for those things that you're never going to get across, and will hold them, like Robert Hillman has this piece about backfiring boilerplate. The courts will hold them to this thing that they never read in the first place, so it's worse for them rather than better. So you abandon notice for them. You use nudges. You use this more visceral styles of notice for a few things you can actually get across. And then you require a lengthy privacy disclosure that has the kind of technical detail that a sophisticated entity will be able to respond to. And you'd assume that no consumer will read it unless they really want to, right? In other words, there's more moves here. And the problem is that the alternative to notice and choice, and again, this goes to something Alessandro Acquisti said, but I mean, notice is the worst form of regulation except for all the alternatives. We know the dangers around command and control. We know that some of the other dangers. Now, I know there are people in this room who disagree with me on that. I've heard their disagreements about that. But it seems to me that, getting people to disclose an information environment is one viable tool that we have, and we haven't made all the moves. So, I mean, I don't think notice works for all things in all circumstances. I increasingly am of the view that we're going to have to go beyond notice in certain contexts and have written some things in that vein. But there's some utility there, and we have not mapped out this entire field. Just because the stuff that we have chosen has not been wise doesn't mean that there aren't other moves to be made.
Great, I think we should open to the floor.
perspective, one of the things that the privacy and personal data colleagues are hammering into the rest of us in Europe is that there is a difference between privacy and personal data policies. They are two different, they overlap largely, but they do have different bases. And the framework for personal data is more designed to protect autonomy and control over your data, like the information on the commercial transaction I carry out or my credit record are not the most private information. These are commercial dealings, but I want to have control over the accuracy and who does what with that and so on. And I think the discussion would benefit from sometimes making the distinction between the two sets of policies a bit more clear. And my question was, in the speeches, I missed a bit more elaboration on the possibility to use labeling and certification systems. Assuming that we can agree on how to label, okay, that's a big assumption. But if you look, for instance, at what happened with energy efficiency labeling, the evidence that I know is that it pulled the market up. At some point, people start to say, I don't want to have an F for a fridge, I'm going to go for A. And then all the manufacturers are at A, then they create A+ and E++ categories. So without having to explain to everyone how a fridge works and how to make it more efficient, as long as you can agree on what will qualify at which level. Would that be a possible way to simplify the matter?
So, I think so. I made a similar point to Chris Hufnagel, and he said it was less like energy ratings and it's more like milk, where you have to describe what is in milk and what the fat content but also you can't have a lot of cyanide in it. In other words, there are both substantive restrictions on milk and also obligations around notice. And again, we need to figure out what the maximum might be. There are certain things you can't do with fridges, and that's not on purpose. They have to be safe enough, right? But then notice has some additional role. And I think when we figure this out a little better, and I think precisely you've identified the problem in my view, which is that it's so difficult to quantify. There was for a time some hope that third parties would be able to validate, so you'd get a seal saying I'm secure enough and whatever. Part of the problem with that is the David Brin problem of who watches the watchers. I mean, you have actual FTC actions against certification providers for lying about what they did in order to certify, and so it's you have that possibility. But maybe if the federal government were in a position to do it, I don't know. There's promise there, is all I would say.
Yeah, so seals, it seems to be the most promising idea. A label has to be very simple. So a restaurant grade has assumingly been so successful because it only deals with one dimension, which is the restaurant hygiene, and it's something that it affects a decision that you take at that moment, and it affects your well-being right away. So that's why they're highly effective. Arguably, Dan Ho has a paper where he says they might have been so effective in other areas. Whereas privacy policies have this whole mix of things and putting all that in one grade. And if you add to the mix that people might have heterogeneous preferences, it might create a bit of a problem. Or if the preferences vary by context, that might create another problem. So seals might work, except that seals have failed miserably. And maybe it's, perhaps it's what Ryan said, that the model of seals haven't just been the most effective. But in a part of the study of privacy policies, I track the types of seals that companies claim, and most of them don't. And the ones that they do are just trustee, but a very small percentage, and they're very diffuse. So it's very hard for consumers to understand one particular seal is one salient metric that makes it easy to compare across firms. If there's 100 different seals, then it's useless, and that's what we see right now: either nothing or a million.
Hi, my name is Bill McManus. I guess this is primarily for Florencia, but at the beginning of your talk, you were talking about the potential for an informed minority. Has there been any kind of research or studies done comparing the different privacy policies for particularly competitive sites and things? Is there really any substantive difference between any of the policies? Or is it, I don't like this one, but I can't go there because they're just the same?
so I don't know about other studies that there probably are, but the ones that I know is I've compared these 6 different markets, and there's, so I measured if there are any statistically difference, statistically significant differences in compliance with fair information practice principles, basically, the 2012 FTC guidelines, the earlier ones, 1973 FIPS, depending on market. And the only difference that I saw was that there's higher compliance in cloud computing services. So the privacy policies of cloud computing firms on some dimensions are much more adhere to a greater degree to fair information practice principles than other markets. And what I hypothesize in the paper is that, and this is a very, very rough hypothesis, is that cloud computing firms have a different kind of mix of clients, including a lot of firms and firms that trust their trade secrets and employee data to them. So maybe firms who want to cater the business of those more sophisticated users are offering a better term to all, and those sophisticated users are providing a positive externality on all consumers by getting better terms. But other than that, there's not that much difference.
I guess I didn't make my question clear at all
Okay.
because I don't think it raised. Just take 2 shoe store websites.
Okay.
Has anybody done any research across like all shoe store websites? Are their privacy policies the same?
Oh.
So that, I mean, you had said it for,
No, they're not
minority.
all the same. There's variation.
Are there?
There's variation in some dimensions and less variation in others, but they're not exactly the same, no. At least within the 6 markets that I studied.
okay.
For instance, of two websites that test your genes, like genetic testing websites, there was a time when Navigenics committed to push back against government requests for information, and 23andMe did not make a commitment like that. And that's something that would be salient to people potentially. So sometimes you do see that, but it gets lost in the shuffle.
Yeah,
Yeah.
there's so many.
Thank you. Question for Jonathan, Professor Barron, for you. So imagine 2 people, one of whom is removing their clothing in their home when the window's open, and one of whom is removing their clothing in the doctor's office. I take it that your view would be that for utilitarian reasons, we should treat the person removing his or her clothing as the cheapest cost avoider. They can just close the blinds. But it would be a lot more complicated in the doctor's office for the person to protect their privacy from cameras because they don't know the layout of the office, they don't know the people involved, et cetera. So then I guess take it that the nurses and doctors would be the cheaper cost avoiders.
Yeah.
But in both instances, the reason why we are uncomfortable with cameras and the nudity involved is that there's something that makes us uncomfortable about sexually prurient or salacious voyeurism. And I wondered what your thoughts were about the utilitarian case for salacious sexual voyeurism.
Well, in the experiment, I just asked the subjects, and they all agreed that the harm was worse than, the harm was much greater than any benefit. So they seemed to think that the pleasure that the person got from seeing this through a telescope was trivial compared to the harm to the woman, and didn't think much of it. And now what I think, what I think is the correct utilitarian view is maybe a little more complicated. It has to do with the same kind of, that is, do evil desires count in the utilitarian calculus? And there's a large literature on that, and I find it convincing to say that they do, but with a lot of buts. That is, you also have to look at things like the effect of ignoring those desires on the development of similar desires in the future and people's willingness to suppress them when they have them and things like that. There are a lot of secondary effects there, but so if that's the answer to your question, but as there are big debates among utilitarians about that very issue. The one who I think who convinced me was Richard Hare.
I guess I was thinking that it might seem to a lot of people that clearly the answer to the problem is just closure through the blinds. But if
Yeah.
if the background to that is that we want to stamp out certain kinds of voyeurism in our society, then what the law should be becomes a different question.
So then there should be law invoked against the person for having and trying to satisfy those desires. That's a good point. And indeed, that should be part of the calculus. And in the next study, I have to ask directly about that.
Thank you.
Yeah.
I think we have time for one more question.
Hi, yeah. So the EFF have been doing this thing for a couple of years. So they give companies stars on a basis of dimensions related to who has your back. And one thing that's been interesting is that I found out that companies that have gotten bad number of stars, engineers working at the company who are pro EFF type people have actually gone to management of their companies and been like, hey, why are we getting a silver star on this? I'm the type of person who likes good free stuff and civil liberties. So one of my questions kind of coming on that is, to what degree do any of you think that privacy policies also function as a document that allows employees to know what their business does? And does that allow a way, as we've seen with the have your back stuff, to have positive change within a corporate environment?
Well, that's a great idea, have change from within, and the clearer they are, the more the employees can be informed and change things. You can have some kind of whistleblower type things when the company is not complying with something so one of the questions that I had once is, well, assuming it's all very clear, a lot of these things are not verifiable. How can consumers even, and the harm is so uncertain, how can you discipline firms? And you can think, well, you've mentioned the role of employees, and one is having clearer contracts, assuming this is a route that's worth pursuing, and the other one is, maybe whistleblowers. But that's a great idea.
So, I mean, I think that today privacy policies are written after the fact by lawyers in order to reserve as many rights as possible to the company, and so in that way they might not be very interesting to the average line employee of a company. One thing that I had suggested a few years ago and seems to be getting some traction would be the idea that for certain kinds of experimentation on consumers, treating consumers like subjects, that you'd have a kind of ethical review board internally that would permit others within the organization to hear from their colleagues about what kinds of things they want to be doing. And I call it a consumer subject review board. And that I think would be kind of a more meaningful engagement potentially. Facebook, it turns out, is doing something like that. And the White House most recent draft of their Consumer Bill of Rights has privacy boards that appear to be modeled on that idea. And I can give you this, it's called Consumer Subject Review Boards. It's in Stanford Law Review's online component. I think that's a more effective mechanism of this, a good mechanism for getting at what you're concerned about rather than a privacy policy.
Thank you.